Franklin, you understand me, correct? Do you understand me? All right, Mr. Franklin, do you understand? Yes? You got to speak up, sir.
Yeah.
Okay. All right, is anyone aware of any other cases that we need the Spanish interpreter for? No? All right, thank you. We thank you for your help, and we don't need you for any additional services. All right, thank you.
Thank you, Your Honor. Have a great day.
You too. Okay, as to Jeremy Franklin, you're charged with indecent exposure of sexual organs, and your bond is 500. The court will appoint the public defender's office to represent you, and the court will also order that you have no contact with the victim and not return to the area of 38 North Terry Avenue in Orlando. All right, no return, no contact. Thank you. The public defender's office is appointed. All right, thank you. Next is Samuel Lamar Taylor. All right, good afternoon, Mr. Taylor. You're here on the charge of trespass on property after warning. Your bond is 500. We'll also order that you not return to the location where this occurred, 1200 West Colonial Drive, Orlando, in the Wawa, and the public defender's office is appointed. Thank you. No return to the Wawa. Thank you.
Okay, I'm getting out today.
Not as long as you're on bond in this case.
The officer and the state lady came to see me, and she said I was getting out today.
Okay.
State lady.
Well, whatever they told you, sir, is good.
Excuse
by
me?
I know.
You gonna keep doing this war? I'm the Lord of the Lords, man. I'm coming to dismiss.
Okay, we're done with this case. Thank
Okay,
you.
man, I'll leave this place a curse and a perpetual affliction.
Okay, next is Weston Jackson. Mr. Jackson, you're here today on the charge of petty theft. It's alleged that you committed this offense on the 20th of September. And it's alleged that this offense occurred near 2728 East Colonial Drive. It's alleged that you took merchandise from the store there. The court entered plea of not guilty, set the case for trial, appoint the public defenders. Again, the bond is 1,000. Thank you, Mr. Jackson. Okay, next up is Phil Travarius Javon Parrish.
Parrish?
Phil Parrish is the name.
He missed the other ones.
Okay.
Parrish.
All right, so Jeffrey Hardy is actually next. Jeffrey Hardy. Who do you have next? Okay, they're just out of order. I got Marcus. Okay, Marcus Robinson.
He's mental health.
All right, thank you.
Which one?
This public defender's office was previously representing Mr. Robinson. Can you do a waiver of appearance?
Yes, Your Honor. I will waive. Enter denial. Thank you.
Division 50, VOP status, October 17th at 9 o'clock.
Okay, and it's probably no bond since it's a VOP. Okay, I think these got rearranged. Okay.
That's Thursday.
Okay, so next is Christopher Rosa. Good afternoon, sir. You're Christopher Rosa.
Sir. Christopher Damien.
Oh, that's what.
Okay, Mr. Rosa, you're here on a charge of violation of pretrial release conditions.
And we will enter a plea of not guilty, Your Honor.
Division 50, pretrial conference, October 21st at 9 o'clock, courtroom 4E.
All right, and the Public Defender's Office is being appointed for Mr. Rosa. Next up is Darius Hardy.
Here he is.
Good afternoon, Mr. Hardy. Sir, you're arrested on a charge of petty theft, retail theft.
Yes, Your Honor. State did convey an offer to Mr. Hardy of an adjudication of guilt, credit time served, no return to the Circle K at 2705 Silver Star Road, restitution in the amount of $35.88, and cost of investigation of $56 to OPD.
Can I have just a moment, Your Honor? I don't know why. I'll print one out, so I don't have all of them.
That's fine.
I thought it was only two.
All right, so we're on the Jeffrey Darius Hardy case. And,
Your Honor, could I have just a moment? It's just that my, when I printed this, it only printed two, and I think the printer paper went out.
all right, could the state recite the terms of the plea again?
Yes, Judge. It's an adjudication of guilt, credit time served, no return to the Circle K at 2705 Silver Star Road, restitution in the amount of $35.88 to the Circle K, and cost of investigation of $56 to OPD. And I will be following that up with a restitution order as well, Your Honor.
We're gonna enter a plea of not guilty, Your Honor.
All right, so we'll note that Mr. Hardy is entering plea of not guilty, will set his case for trial, and the Public Defender's Office is being appointed, and set the bond on the case at 500.
Your Honor, I believe it already has bond.
I don't see it.
It's an arraignment, Your Honor.
Okay,
Division 63, pretrial conference, October 27th at 1 o'clock, courtroom 10B.
yes. All right, next up is Al Pacino, June.
Al Pacino. I don't see an attorney. I don't see that. Is it Jean?
The last name is spelled Jeune. First,
I will waive and enter a plea of not guilty, Your Honor.
all right, so the court will accept the waiver of appearance as announced, set the case for trial appoint the Public Defender's Office to represent Mr. Gioni, and we'll stay whatever the bond is.
Division 50, pretrial conference, October 21st at 9 o'clock, courtroom 4E.
Thank you. Next up is Avis Peterson, excuse me.
I will waive and enter a plea of not guilty, Your Honor.
Okay, the court will accept the waiver of appearance, plea of not guilty, appoint the Public Defender's Office, and what is the bond in that case?
Division 85, pretrial conference, October 17th at 9 o'clock, courtroom 4A.
Okay, next is Simeon Pierre. All right, good afternoon. You're Simeon Pierre?
Yes.
Okay, you're here on two offenses, criminal mischief. It's also a second count of trespass after warning.
The first will enter a plea of not guilty, Your Honor.
Okay, the court will note that a plea of not guilty has been entered on behalf of Simone Pierre. The case will be set for trial, pretrial.
Division 62, pretrial conference, October 31st at 8:30, courtroom 12C.
Thank you. Next up is Phil Travayas Parrish. Phil Parrish. Are you Phil Parrish? Okay, okay. Okay, Mr. Parrish, you're here on a charge of petty theft or retail theft. It's alleged that you were shoplifting at a public store on Orange Avenue. It's 2873 Orange Avenue in Orlando. Your bond is $250. The court will appoint the Public Defender's Office in your case.
Your Honor, state would ask for a no return.
The court will also order that you not return to the public store that I just mentioned. It's 2873 South Orange Avenue in Orlando. Bernard Sealy.
Which one?
It's
Sealy?
Bernard Sealy.
I will waive and enter a plea. Sorry, waive, Your Honor, the appearance.
All right, the court will accept a waiver of appearance by the Public Defender's Office, appoint their office to represent Mr. Sealy, set the case of trial. He has a bond, $500 on the trespassing charge, $100 on the petty theft charge. Derek Allen Smith is next.
Yes, sir.
Good afternoon, Mr. Smith. Mr. Smith, you're here on two charges. Criminal mischief, his first charge.
Yes, sir.
Second charge is resisting an officer without violence. The bond on the first charge is $500, $100 on the second charge. And the court will also appoint the Public Defender's Office in your case. $600, sir. Thank you.
Your Honor, state would request a condition of a no return, no contact. However, there's also a second case. The 229 AE. And in the 229 AE, I don't believe there is a factual basis. It's contained in the first affidavit.
So, Your Honor, we are okay with you setting a bond, in this case, and waiving any defects. I did read the facts of the battery in the, other case, 2022 MM228 AE. The battery is listed in that case, however, it was not put in the actual battery case.
Okay, so the court will go ahead and leave the bond as it is in MM 228, 500 on count one, 100 on count two. And as to the battery case, it will be stayed at 500. And we'll find that probable cause for the battery is in the first affidavit. The public defender's office is appointed to represent Mr. Smith.
Your Honor, there was a no contact, no return, correct?
No contact and no return.
Thank you.
Next up is Jeremy Antonio Tucker. Thank you. How about Gregory Carter?
Gregory. Your Honor, can we reset for tomorrow?
All right, we'll recall Mr. Carter's case for tomorrow. Lamarcus Bernard Robinson. Okay, Mr. Robinson, you're here today,
Good morning.
having been charged with the offense of I have the charge as being indecent exposure, and that is an Osceola County case. Is that correct?
Yes.
All right, so you'll have to go back to Osceola County for that case. So you'll be transported out if you transported back if you don't make bond.
Your Honor, the offer from the state to resolve the new law is an adjudication of guilt and credit time served.
Are we talking about Mr. Robinson?
Yes, for the alcoholic beverage.
So
No action on that one.
Appreciate it.
All right, what is the second charge for Mr. Robinson?
he just has the open container, Your Honor, the city and county ordinance. So he would like to resolve that case, and you've already taken no action on the out on bond.
All right, so is the state making an offer for Mr. Robinson as to,
Yes, Your Honor, the offer conveyed to Mr. Robinson on the open container was an adjudication of guilt, credit time served.
and how much time served does he have?
2 days.
Okay. Okay, would you please raise your right hand, Mr. Robinson? Sir, do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, so help you?
Yes, sir.
And tell us your correct name.
Lamarcus Bernard Robinson, Jr.
All right, you understand that the plea agreement which has been worked out for you, you can take your hand down now.
Yes, sir.
All right, so you understand if you're in a plea of no contest, is that how he's pleading, counsel?
Yes, Your Honor.
You'll be sentenced to 2 days with credit for time served, and the court will also require you to pay court costs within the next year. You understand what your sentence will be?
Yes, sir.
All right, so are you freely and voluntarily entering your plea of no contest to the open container charge.
Yes, sir.
And counsel agree that there's a factual basis for the plea,
Yes, Your Honor.
and you can assure the court that you've gone over the plea form with Mr. Robinson and that he appears to understand it.
Yes, Your Honor.
All right, the court will accept the plea, find you guilty, adjudicate you guilty, impose a sentence of 2 days with credit for time served, also impose court costs, and require that it be paid within the next year.
Thank you, Your Honor.
Thank you. Okay, thank you. Okay, next I have is Dante Rucker. Is that you, sir?
Yes.
You're also here today on an open container violation, and the bond in your case is $250.
Your Honor, state did convey an offer to Mr. Rucker of an adjudication of guilt, credit time served, and he does also have 2 days credit.
And you would like to accept and enter a plea of no contest, Your Honor.
All right, Mr. Rucker, do you solemnly swear or affirm that the testimony you're about to make here today is the truth, the whole truth, so help you?
Yes.
All right, you can take your hand down. All right, do you understand the plea agreement
Yes.
which has been worked out for you, which involves a sentence of 2 days with credit for time served? And so you already served the 2 days, you'll be adjudicated and required to pay the court costs within the next year. All right, do you understand the plea agreement?
Yes.
And are you freely and voluntarily entering your plea?
Yes.
All right, and counsel agree that there's a factual basis for the plea,
Yes, Your Honor.
and you can assure the court you've reviewed the plea form and your client appears to understand that.
Yes, Your Honor.
All right, so the court will accept the plea and impose the agreed upon sentence. All right, 2 days with credit for time served, court costs. Okay, Ronnie Thomas. Good afternoon. All right, Mr. Thomas, you're here on a city law violation which involves camping or sleeping on a public sidewalk.
Your Honor, state did convey an offer to Mr. Thomas of an adjudication of guilt, credit time served, and no return to 635 North Westmoreland Avenue.
Yeah, I'm trying to figure out something. No return to the sidewalk?
It's 635 North Westmoreland Avenue in Orlando.
Was a business, the business called, but they didn't want him out there. I believe it was around the Arena Food Store.
I don't go there anyway. I wasn't there, I was at the sidewalk. But yeah, I agree.
So, Your Honor, Mr. Thomas would like to accept and enter a plea of no contest.
Okay, Mr. Thomas, would you raise your right hand to be sworn in? Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, shall help you?
I do.
And your correct name is Ronnie Dwayne Thomas, correct?
Yes, sir.
All right, do you understand the charge that you're pleading to?
Yes, sir.
All right, you got to speak up so I can hear you.
Yes, sir.
You don't have to say yes, sir, but you do have to say yes or no or whatever your response is. All right, so you understand that if you plead no contest, the court will impose the agreed-upon sentence of 2 days with credit for time served. You'll also be ordered to pay court costs within the next year. All right, and you want to go along with the plea agreement, correct? You want to accept the plea, right?
I do.
All right. All right, does council agree that there's a factual basis for Mr. Thomas' plea?
Yes, Your Honor.
And you believe that there's a factual basis for the charge that he's pleading to?
Excuse me.
Council agree that there's a factual basis?
Would you please let them know that I was never at the arena store to begin with? I was on the sidewalk.
Well,
That's the sidewalk. You gonna tell me no longer to walk on the sidewalk anymore?
okay, well, yeah, what I suggest, Mr. Thomas, that if you got a problem with this, that you not enter plea and you can have a trial and then you can,
What I'm trying to do,
Ray-
Your Honor, is get an understanding.
Should I have one moment, Your Honor?
They're saying don't return to that sidewalk, because I was on public property. I was not on nobody's personal property.
well, I don't know what you're asking me to do. The charge will not be dismissed, and this is first appearances. I tell you what the charge is, I tell you what the bond is. It was your attorney who told me that you want to enter plea. And the question is, do you want to enter plea or not? If you want to
I'ma enter the plea.
raise defenses, I
Problem at all. I just
suggest.
I wanna have a complete understanding of what it is that they're telling me not.
Okay, well, they,
Yeah, because I was on the sidewalk. I was not on nobody's property.
It's part of the Arena Food Store property, so that area in front of the Arena Food Store is where you cannot go back to. So they're not saying you were directly in the store or right outside, but whatever is connecting to Arena Food Store, you cannot go back to, that sidewalk right there. So do you agree?
I agree.
okay, well, you're gonna have to, pay attention, and you're gonna have to answer the court's questions. And, I'm not going to, continue doing this. Either you can accept the plea or not.
I accept the plea, Your Honor. I am so sorry.
All right, so you understand that you'll be ordered to not return to the area surrounding the Arena Food Store, which is located near 635 North Westmoreland Avenue. You understand that?
Yes.
All right, and council agree that there's a factual basis.
Yes, Your Honor.
All right, the court will accept the plea, impose sentence of 2 days with credit for time served, and order that the defendant not return to the area 635 North Westmoreland Avenue. Okay, and I need a plea form for Mr. Thomas.
I'm sorry?
I need a plea form for Mr. Thomas.
Can't see, Your Honor. He's blind.
100%.
So normally when he comes in here, we just do the plea orally.
All right, thank you.
And, I'm trying to refind it.
Okay, how about Devontae Hunter?
It says revoked, however, it says he
He
has ID
doesn't.
cards.
Yeah, he doesn't have one.
One way or the other, whether, I believe it was, you can have an ID card and you can still get doors. I believe. don't
I
think it
can't
was.
find it, that's what I was looking.
I had the case law somewhere and I was looking through my email. Continue trying to get an ID. Statusing this month. Arguably more court costs, so he's gonna have to pay out to it.
I'll reset him for the end of the document. Let's see if we can find this out. 'Cause I don't want it. Yeah. That's not true. That's my only thing.
Good afternoon, Mr. Hunter, Devontae Hunter. You're here on a charge of driving while your license had been suspended or revoked on September 20th of this year.
Your Honor, in this particular case, Mr. Hunter, can we recall him at the end of the docket? Me and the state are working out an offer to resolve both cases. We're still looking into one thing, so I just want to make sure I'm pleading him to the right charge, because he doesn't have a license.
All right, is correction okay with that? Okay, I will recall him.
I just need to make sure we're pleading to the right.
I have Andrew Joseph McCarthy next. Thank you. How about Carlton Lee Brown? Dominique Javier Burton. All right, good afternoon, Mr. Burton. You're here charged with grand theft, and your bond is $1,000. And the court will appoint the public defender's office to represent you. Your bond is $1,000. Thank you. Eric Thor Fleming.
Sir.
All right, good afternoon, Mr. Fleming. You're here on a charge of, actually, it's failure to appear on a sales or delivery of cocaine charge, and no bond was authorized for you. The court will appoint the public defender's office in your case, and your case will also be set for a trial. All right, thank you. Next, I have Quenisha Jean Gatewood. Good afternoon.
Good afternoon.
Ms. Gatewood, you're here on a charge of grand theft. All right, in your case, it's alleged that you committed this offense at the Tommy Hilfiger store. And it's alleged you took merchandise, or attempted to take merchandise from that store. And the bond in your case is $500, and you're on bond in the possession of controlled substance case. Actually, it's an ROR.
Sign pretrial diversion. She's in pretrial diversion, Your Honor. It asks that you take no action.
Does the state wish to be heard? And the question,
Given that they're not related, state would request no action and let pretrial diversion, kick her out if they're going to.
All right, so the court will not take any action.
The state
And,
would request a no return to the Tommy Hilfiger on International Drive.
So the court will take no action on the case that she's on bond, but it will order no return to the Tommy Hilfiger store. All right, thank you. Jorge Antonio Gomez Sierra. All right, good afternoon, Mr. Sierra. You're here on a possession of cocaine charge, and the bond amount is $1,000.
Your Honor, he qualifies for pretrial.
I would ask for pretrial release, Your Honor.
All right, according to your affidavit, you say that you earn about $60,000 a year.
Make too much to qualify.
All right, the court will not appoint an attorney for you. You should be able to hire a lawyer based upon your income. All right, your case will be set for trial, sir. Thank you. Next is
What action are you taking for his bond?
his bond is stayed at 1,000. Okay, next is Clifford Lydell Good. All right, good afternoon, Mr. Good. You're here on the charge of grand theft. Your bond is $1,500, and you were arrested on a warrant. So again, the bond is $1,500, and the court will appoint the public defender's office in your case. Thank you.
Yes, sir. Thank you, sir.
You have a good day.
Your Honor, state would also request a no return.
The court will also, Mr. Good, the court will also order no return, sir. Okay, I have Essence Green is next.
Or who does not have a driver's license or driving privilege.
I will
is
waive,
under
Your Honor.
suspension.
All right, so we note that the public defender's office is waiving the appearance by Essence Green Jones. Bond is $250 on the charge of petty theft. She has a bond of $1,000 on a grand theft charge. Thank you. Issue.
I don't ROR.
And Your Honor, given that those are both theft-related charges, state would request that you revoke both of those as well.
You filed?
Let's go check.
Okay, so in case 22 CF 958, actually it's 22 CF.
In, Your Honor, in 2022 CF 7040, AO, my client was seen at IA's back in June 18th to date. The state has not made a filing decision. She was released on a 33-day motion with a notice of non-filing. So I'd ask that you take no action on that case. And I believe it's the same for the 2022 MM146AE. Yes, she was released on a 33-day motion state filed a notice of non-filing on or before the 33rd day.
Does the state wish to be heard?
No, Your Honor.
All right, so the court will stay the release conditions of ROR and 22 CF. And that was in 958 and
Okay.
And as to the petty theft case, the bond is $250. And the public defender's office is being appointed. Okay, next is Evan Fabricio Gutierrez. All right, the charge appears to be committing a lewd, a lascivious act in the presence of a child. You're arrested on a warrant. No bond was listed on the warrant. The state have a recommendation as to bond in this case.
Your Honor, I believe it is only an F2, so Mr. Gutierrez is entitled to a bond. However, state would just have to take into account the age of the victim, and just set a reasonable bond.
All right, does the defense wish to be heard?
Yes, Your Honor, when setting the bond, I'd ask that you consider the fact that my client has never been in trouble based on what I'm seeing from the face sheet. And he has community ties, been in the Orlando area for well over a year. So I just ask that you consider that when setting the bond.
Your Honor, just for the record, I believe the age of the victim was 14. And he was watching her to and from her bus stop. While committing like personal sexual acts.
Okay. The court will agree to set a bond of $10,000 and order that defendant not return to the location. He also not go to any school bus stops or schools, playgrounds, or places where children congregate in the Central Florida area. They did not have any contact with any of the victims in this case.
Your Honor, so to be clear, that was a no return to the school, which is Freedom High, no return to the apartment complex,
We'll include the apartment complex as
which I
well.
believe is Berkshire Club Apartments. You said no return to any places children congregate, such as playgrounds or schools. No contact with the victims. State would ask for no contact with any minor under the age of 18 as well.
All right, no contacts with any minors. All right, thank you. All right, and we'll also note for the record that an attorney, Lizette Dominguez, has entered a written plea of not guilty on behalf of Mr. Gutierrez, and that has been filed in open court. Thank you.
Is that a private? Oh, so you have a private.
Okay, thank you. All right, I have next is Jatavia Hamilton.
And I will waive, Your Honor.
Okay, all right, so we'll note and accept the waiver of appearance by counsel and appoint the public defender's office and set the case for trial. Charges burglary of structure. The bond is $3,500. Thank you.
Your Honor, state would ask for no contact, no return.
No contact with the victim. Next is Eric Hamner, Hamner. Mr. Hamner, you're here having been charged with failure to redeliver a hired vehicle. That's the charge. The bond is $1,000. And the court is appointing the public defender's office to represent you. $1,000 bond, sir. Thank you. And next is Mary Morgan Hurd. All right, good afternoon, Ms. Hurd.
Criminal mischief. Letitia,
Oh,
slash on the wall, criminal mischief.
I missed it.
Small, but.
That's fine. As long as it's there.
All right, good afternoon, ma'am. You're Mary Morgan Hurd.
Yes, sir.
All right, and you're here today because you've been arrested on the charge of being in possession of cocaine.
True.
It's alleged that you were in possession of cocaine on the 20th of September near 700 West Church Street. The charge is being in possession of cocaine. The bond is $1,000, and the public defender's office is being appointed to represent you. All right, thank you, Ms. Hurd.
How y'all doing?
Okay, James Lewis Hill.
Yes, sir. May I ask for my public attorney something?
Sure, you can ask your attorney something.
How much you were carrying. Thank, thank you, Your Honor. Qualified.
All right, Mr. Hill, you're here on a charge of, is that a trafficking state? Is that trafficking and ecstasy?
In excess of 10 grams, under 200 grams of MDMA.
All right, and so the charge is having that amount of ecstasy in your possession, and the bond is $100,000. It's $100,000. The court is also appointing the public defender's office to represent you in this case. All right, thank you, Mr. Hill.
Your Honor, did you say the bond?
Stayed the bond.
Your Honor, I would ask that you at least consider reducing to 75,000. If you look at the affidavit, he was very cooperative with the officers. They even put in there, he was polite and cooperative during the investigation. So I just ask that you consider that factor and reduce it to 75,000 as opposed to 100.
And Your Honor, state's only argument is the lack of community ties. I believe Mr. Hill is from Georgia and has criminal history out of Georgia, both violent and drug-related offenses. And I believe also has a current active warrant out of Georgia with interstate pickup only. So state's concerned regarding his willingness and ability to show back up to court to deal with these charges, given that it is a serious offense.
I had talked to my
Stop.
Counsel, is there something else?
No, Your Honor.
All right, the court will stay the bond as it is. All right, thank you.
Try to figure it.
Okay, next up is Kadeem Matthews. All right, Mr. Matthews, you're here on 4 separate charges. Count 1 is trafficking in oxycodone with a firearm, no bond. Trafficking in cocaine. All right, can the state help me on that? Is there a different charge from count 1? It's trafficking oxycodone with a firearm, then it's trafficking in cocaine. That's a separate charge.
Your Honor, oxycodone,
I'm not really asking you, sir.
Your Honor, 1 is oxycodone, 2 is codeine, are 2 very different drugs.
All right, so the third charge is possession of cannabis, and the 4 charges, carrying a concealed firearm. No bond on count 1, $250,000 bond on count 2, $1,000 bond on counts 3 and 4.
I think it is. Double check.
Okay,
Your Honor, I
Miss,
do believe count 1 is a PBL, given that it's a trafficking and with a firearm. However, state is double checking, but I am fairly certain it is PBL.
we have an affidavit for Mr. Matthews.
today's purpose. Just let me, if he's fine, let me see what he put in there. I'm trying to see if he filed a notice. Didn't file. Who is it? Hasn't yet. Clerk, do you have any private attorneys on this case that filed a notice? Your Honor, but I would ask that, you not appoint, he did hire an attorney who was supposed to be here today. So I don't know. I understand what you're saying. None of-
All right, do we have
only thing he
anything
can
to indicate anyone has filed a notice of appearance on behalf
Want
of?
to do that?
All right, no,
Have it reset for tomorrow?
we do not have a notice of appearance in the file.
They're going to be held at no bond.
Okay,
Your Honor, he has a private, he said he spoke to his private attorney, his wife paid for it, everything. Could we just, he's asking that it be reset for tomorrow so he can have counsel present.
all right, we'll call it tomorrow on a determination of counsel to see if someone is representing Mr. Matthews. All right, so Mr. Matthews, you'll need to get in contact with your attorney and your wife and have them to file a notice of appearance, and we'll recall your case tomorrow. Thank you.
Can you speak to him? Reset cases is usually heard in the morning at night.
Next up is Michael B. McCrimmon. All right, Mr. McCrimmon, good afternoon, sir. You're here on the charge of possession of methamphetamines and tampering with evidence. The bond on count one is $1,000. It's $250 on count two. $1,250 is the bond. The public defender's office is being appointed in your case. Thank you. Next is Michael Mark Miller. Okay, Mr. Miller, you're here on 3 separate charges. Count one is driving while your license have been suspended or revoked. On September 21st, also driving in violation of your business purpose permit. The bond is $500. Third count is resisting an officer without violence. $1,500 bond. The public defender's office is being appointed. Thank you, Mr. Mueller. How about Dexter Adam Mitchell? Okay, Mr. Mitchell, you're here for failing to appear, and it appears the underlying charges will be trafficking in cocaine. So you got failure to appear, no bond as to each of the 4 failures to appear, no bond. You were arrested on a warrant, and the judge who issued the warrant didn't authorize the bond. No bond. The public defender's office is being appointed. Now, you might want to ask your question to the attorney without talking to the court, but because the proceedings today are being recorded, and whatever you say is being recorded, and there's a possibility that whatever you say could be used against you. We have a prosecutor also present in court who's eagerly listening to see if you're going to say anything that will help their case. All right. Okay, anything else as to Dexter Mitchell?
No, Your Honor.
All right, so the Public Defender's Office is appointed and the bond is not changed. All right, thank you. Jose Antonio Perea.
Yes.
Okay, Mr. Perea, you're here on two charges. In the first case, you have a failure to appear on a grand theft motor vehicle charge. The bond in that case is $6,000. I also have a second charge of a camping ordinance violation, and the bond is $250.
Yes.
This alleges that you were sleeping in front of 310 North Orange Avenue. So the bond on the first case is $6,250. On the second case, the Public Defender's Office is being appointed in your cases. Thank you, Mr. Perea. Devin Terrell Robinson.
Yes, sir.
Mr. Robinson, you're here charged with 7 separate offenses. Count 1, the charge is trafficking in oxycodone. The bond is $500,000. Count 2 is trafficking in methamphetamines. No bond. Is that a first-degree felony punishable by life? Is it?
No, Your Honor, the trafficking in meth over 14 with a weapon, I believe comes in at $100,000 on the bond schedule. State will ask that you stay it at that, as the trafficking in oxycodone over 28, which is count 1, on the bond schedule comes in at $1 million, and it's already at 500,000. So state would ask that you follow the bond schedule on 2, which is 100,000.
All right, count 3 is sale and delivery of a controlled substance. The bond is $15,000. Possession of cocaine with a weapon. The bond is $15,000. Count 5, the charge is possession of alprazolam. The bond is $1,000. Count 6 is possession of a firearm by a convicted felon. The bond is $4,000. Count 7 is possession of ammunition by a convicted felon, and the bond is $5,000. All right. As to count one trafficking, the bond will be stayed, be unchanged. As to count two, we'll set the bond at 100,000. Bond as to count three will be stayed as to count 4, 5, 6, and 7. The Public Defender's Office is being appointed to represent you, Mr. Robinson. Thank you. Next is Andra Rosado Santiago. Okay, Mr. Rosado Santiago, you were arrested on a warrant. It appears to be related to a grand theft, motor vehicle charge. The bond is $5,000. And the Public Defender's Office is being appointed in your case. $5,000 bond, sir.
She has 2 more cases as well.
Okay, hold on. Okay. Okay, there's a second charge of driving without a valid license. The bond is $500. On that charge, the next charge is grand theft of a motor vehicle. The bond is $1,000. The final charge is resisting an officer without violence. The bond is $500. As to the last charge, and the Public Defender's Office will be appointed in each of your cases. All right, thank you, Mr. Rosado Santiago. Next case is that of Richard Allen Russ. Mr. Russ, you're here today on 2 new charges. Count 1, the charge is grand theft. The bond is $500. Count 2 is resisting an officer without violence. The bond is $1,000. It appears that you were released earlier on a possession of cocaine charge and a resisting charge. You were released on your own recognizance. As to those 2 charges, in this case 22 CF 10,971, the court will revoke the RRR on the possession of cocaine. The court will set a bond of $1,000, set a bond of $500 on the resisting charge.
Your Honor, my only, I would ask that, honestly, on this case, you take no action. It's been since April.
Or as to which case?
The out on bond case, and nothing has been filed, and we're in September, Your Honor.
That was the 4866.
Yes, Your Honor. So since April and the state has not made a filing decision, I would ask that you take no action.
All right, what's the state?
There's no objection, Your Honor.
All right, the court will take back what I just said and leave the bond.
Your Honor, I believe when you set bonds on the 10971 case, the grand theft, you stated at 500. And I believe when you said the resisting without, you said 1,000. I believe it was 100. I didn't know if you intended to increase it.
Which one?
Count 2.
No.
Okay.
What I was speaking to the case is that he was on bond for, which was 22 CF 10,971. And
Yes, Your
and
Honor.
we changing that
To no action.
to ROR because the state has not filed an information. Okay, and as to the new case, I didn't change the bond.
Okay.
Thank you. All right, James Say. All right, good afternoon, Mr. Say. You're arrested on a warrant. You had a failure to appear for petty theft with prior convictions. And no bond was authorized on the failure to appear. The Public Defender's Office is being appointed in your case. Thank you. Marcus Edwards Sims. Good afternoon, Mr. Sims. You're being held on the charge of possession of methamphetamines, and your bond is $1,000. The Public Defender's Office is being appointed to represent you. $1,000, sir. Thank you.
So it's 100. No, it's a felony. It has to be resolved downtown.
Shateria Stockton. Ms. Stockton, you're here on the charge of possession of methamphetamines. The bond is $1,000. The Public Defender's Office is being appointed in your case. Thank you. Okay, Miguel Angel Vargas.
Yes, ma'am. Yes, Your Honor.
Mr. Vargas, you're here today charged with home invasion, robbery with a firearm, no bond. As to that charge, the second charge is grand theft of a motor vehicle. The bond is $3,000. No bond on the first one, $3,000 on the second. The Public Defender's Office is appointed to represent you.
Your Honor, state would ask for no contact with the victim, witness, or any co-defendant, and no weapons.
All right, the code will also order no return, no contact with the victim, no contact with the co-defendant, no weapons or firearms. Thank you. Jason Raphael White.
Sir.
All right, good afternoon, Mr. White. You're here and you're charged with burglary to a structure. The bond on that charge is $3,500. Second charge is petty theft. The bond is $500. And I'm also showing that you're on bond for petty theft with a $1,000 bond. Is that correct? All right, the court will stay the bond and I'll set the bond on a new petty theft charge and that charge alone at $1,000. So the petty theft bond will be raised to $1,000 by the court. All the other bond amounts will remain the same. Thank you.
So you're taking no action on the I don't bond, Your Honor?
No action, no action. Okay, Marcus Anton Williams. Good afternoon, Mr. Williams. You're here on a charge of robbery. The bond on the robbery charge is $5,000. The second charge is grand theft of a motor vehicle. That bond is $1,000. There's a third count of grand theft, and the bond is also $1,000. So you got 3 charges. The total bond is $7,000, and the Public Defender's Office is being appointed to represent you. Thank you, Mr. Williams.
We're not gonna reduce it. Your Honor, my client can afford the $5,000 bond. Would you consider reducing to $3,500 on count 1?
Your Honor, state would object. Mr. Williams has a fairly lengthy criminal history with several other theft-related offenses. He had a 2021 non-arrest petty theft, a 2022 petty theft 2 prior that is currently open, a 2022 grand theft motor vehicle, grand theft firearm, grand theft that was no billed, a 2019 attempted felony murder, burglary of a dwelling with assault or battery that was no billed, a 2018 grand theft he pled no contest to, And Your Honor, state can continue. However, there are several other theft-related offenses. Therefore, I believe the bond amounts are in keeping with his criminal history.
The court will deny the request to further reduce his bond, and the bonds will be stayed as they are. Thank you. Do we know anything about this one?
Who is this? Can we, oh, we're doing the private counsel? Yeah, let her do the reference. Because I don't. All right. She just needs action 2022.
Huh?
Hello?
Hello, Your Honor, how are you?
I'm pretty good, except I can barely hear you. We're trying to raise the volume. All right.
I'm right, I was on my way there. I don't know how long you're gonna be there, but you said you only had 3 more cases, so.
Okay. We could do it over the phone if, assuming that you're comfortable with that and the state is comfortable with it. We called the case on yesterday for Woolner Duran, and that's case 2022 CF 10,892. And there was a question as to the probable cause as to count 2, aggravated battery with a firearm, because from reading the affidavits, we couldn't see that there was a second victim, and the state was given an opportunity to supply additional information as to count 2 or not. All right, counsel?
Your Honor, state did obtain a supplement. May I approach?
All right, you may.
Is the state showing the court a document?
I believe the issue on the PC for 2 was whatever the injury that victim number 2 sustained to sustain the aggravated battery with a firearm. I believe the supplement does mention the injury sustained by that second victim, Ms. Waleed. So state would contend that there is PC for count 2. I would ask that you set bond accordingly.
All right, so for the record, the court has been provided a supplemental case report dated September 20th of this year, and the report was made by Makeson Cherry, and it reads as follows. Due to Atilia Waleed, victim in parentheses, sustaining injuries to the head from one of the bullets, probable cause was found for a second count, a violation of Florida Statute 782.05, subsection 1, subsection A, subsection 2, dash 14, aggravated battery with a firearm, period, end of quote. All right, counsel, do you wish to be heard on the issue of probable cause as to count 2, aggravated battery with a firearm?
No.
All right, so the court will find that the state is satisfied. The court's concerned about probable cause as to aggravated battery with a firearm as to count 2, and so the bond will be stayed at none at this point. Okay.
I was asking the court to consider a bond in light of the fact that my client has no prior criminal history, has been on his job for 11 years, is a lifetime resident of Florida, and I believe that he was being attacked by individuals downtown.
Your Honor, I do believe he is entitled to a bond as the way it is currently charged. However, state would have you take into account that he does have a prior failure to appear, a prior felony and prior misdemeanor convictions, and the facts alleged within the affidavit are incredibly dangerous, multiple shots fired downtown where many other people were. I believe on a weekend night around where all the bars were downtown, including Celine Orlando nightclub, hence how one of the victims got injured. So it is inherently dangerous, and Mr. Durand is a danger to the community based off the allegations within this affidavit. So state would ask that you take that into account when setting his bonds.
Yeah, he's not, in light of the fact that he's worked for his job for 11 years, in light of the fact that he's a lifetime member, he has, I believe it's a 2014 case that was adjudication was withheld for, I believe, possession of a cannabis or something like that is what he has. And the other thing is just basically traffic and driving. He does not have any kind of significant criminal history. His entire family is in Florida. If he could tell you, I'm not sure, I believe he works for UPS. I mean, he could tell you that. And he has his, right now, he has his job. This is not a person that just took a gun and went downtown and started shooting people. This is not this type of situation.
Well, certainly shots were fired, at least according to what I've read. But in any respect, the court will agree to set a bond of $7,500 as to count 1, and as to count 2, will reduce the bond of count 3 to $1,000 and impose the following special conditions: no contact with the victims, not possess any weapons or firearms, and not return to the downtown area where this incident allegedly took place. So it's $16,000.
Your Honor, is there a bond on count 1?
Count 1, the bond is $7,500. The same for count 2, $1,000 as to count 3.
Thank you. Okay, I had to write it down. I appreciate you, and you guys have an awesome day.
All right, take care. Okay. Okay, how about Devontae Hunter?
Okay.
All right, the council wanted to recall this case.
Yes, Your Honor. I don't have the case number. You want to say the offer?
Your Honor, state did convey an offer to Mr. Hunter of an adjudication of guilt, credit time served.
And Mr. Hunter would like to accept the state's offer and enter a plea of no contest. And in exchange, Your Honor, I would ask that you take no action on the out on bond case. We are working with him to get his driver's license. So I just ask that you take no action on the out on bond.
All right, so the plea agreement only applies as to the new charge.
Yes, Your Honor.
And the new charge is 22 CF 5355.
I need to see,
CT.
oh, CT. This number.
I don't have it either, but it's a traffic, so.
Okay, let me.
Okay, and how much time served does he have?
2 days, Your Honor.
Do you see a ticket?
Huh?
Traffic ticket.
I don't know. We don't get them because we don't deal with them.
Okay, the state is in agreement with the plea offer as announced. Adjudication of guilt, credit for time served, court costs.
Yes, Your Honor.
All right, is there any reason why Mr. Hunter can't obtain a valid license?
Your Honor, it's my understanding he's never had one. However, I do believe he does have a lot of outstanding traffic.
Your Honor, we did a motion.
fines.
Oh, sorry.
Sorry, go ahead.
We did a motion to, I forgot what it's called. I'm so tired. We already filed a motion to get all of his fees brought together with the clerk's office. He's actually working on paying those off so he can get a valid driver's license, which is why I didn't want you to take any action on the out on bond because we're actually working on getting his license and he's actively paying on the fees.
And just for the record, this would be his second Willis within 5 years. So he has one more until he's HTO.
I don't know.
The court will also impose 6 months of probation and impose special condition that he not drive without a valid license. And the reason is that, at least according to what I'm reading, he is licensed, or his ability to obtain a license has been suspended since 2013, and he continues to accumulate traffic fines. He should not be driving. And so the point is, if he doesn't drive, it won't be a problem, but I'll require 6 months of probation in addition to the other terms in order that he not drive without a valid license. Counsel, you might want to discuss that with Mr. Hunter.
Your Honor, we're not going to accept the offer.
You will not? All right, thank you. All right, so we're at a plea of not guilty and set the case for trial, and the public defender's office is being appointed, and he's out on bond, and the bond amount is $10,000. The bond amount in this case is $2,500.
I would object to a $10,000 bond.
Well, that's, he already made that bond. That bond was already posted.
I mean, not a $10,000 bond, but revoking.
I didn't do anything with that.
Oh, okay. $2,500 on count 1.
So you're taking no action.
All right, so the charge is driving a suspended license, and the new case, and the bond is $2,500. My point is simply that he's on bond for the same charge, and the bond amount is $10,500. His bond is stayed. No action is taken on the case that he's on release.
No action on the out of bond, 25 on the new.
No, he didn't revoke. Again, that's why I was confused. I only see 150. Yeah, that's what I was like.
All right, anything else from state or defense?
Nothing from the state.
Nothing from defense.
All right, the court will be in recess. Okay, are we done with the interpreted cases? All right, so we are done with the interpreted cases. Let's see. All right, Shanquell Lynch. You're here today charged with aggravated stalking after an injunction was issued Currently, you have no bond. The court will also find you insolvent and appoint the public defender's office to represent you. All right, does the state have a recommendation as to a bond in this case?
Our state will just leave it within your discretion. Ms. Lynch does have a fairly lengthy criminal history of other BAT DVs, assault DV, and probation violations. So we just ask that you take that into account when setting her bond.
All right, does council wish to be heard?
Just ask for a reasonable bond.
All right, the court will set a bond of 10,000 and impose special conditions that Ms. Lynch has no contact with the victim, not return to the victim's residence or the place where this occurred, and will also require an ankle monitor. All right, thank you. Yeah.
I'm sorry.
Yeah, I don't believe Orange County does ankle monitoring.
I'm sorry?
I don't believe Orange County has the capability to do ankle monitoring. So if that's a condition, I don't believe she'd be able to bond out.
And is that is true? No,
Yes.
no electronic monitoring?
Yes, Your Honor.
All right, I'll scratch that provision then, all right? Everything else. Okay. Cameron Moniak. All right, good morning, ma'am. You're here today and you're charged with 2 counts of neglect of a child. The bond on the first count is $1,000. Bond on the second count is $150. The court will find that you're insolvent based upon your affidavit and appoint the public defender's office in your case. Thank you.
Your Honor, state would ask for no contact with the children and to comply with DCF.
All right, the court will order that the defendant complies with DCF and have no contact with the children. All right, thank you.
Your Honor, she's also out on pretrial diversion.
The court will stay the pretrial diversion is a totally different and unrelated charge.
No action.
No action. Thank you. All right, next up is Cynthia Lou Shinerwin.
I will waive the appearance, Your Honor.
All right, we'll note that a waiver of appearance has been entered by the Public Defender's Office, and don't have an affidavit. We'll need one from Ms. Shinerwin.
Your Honor, since COVID happened, you can't temporarily appoint us, and then they can have it filled out later.
Okay, the call will temporarily appoint your office to represent Ms. Shinerwin. All right. All right, thank you.
Is the bond stayed, Your Honor?
The bond is stayed, correct. Thank you. Crystal Blair Cargill is next. Ms. Cargill, you're here today on the charge of aggravated domestic violence battery. The court will set bond at $5,000 in this case, or that you have no contact with the victim, no return to the residence. Will permit you to go back one time with the presence of law enforcement to obtain personal belongings. $5,000. All right, thank you. The court will appoint the public defender's office also. Thank you. Where did I sign it? No, there's I think this form is for the clerk's office. Next is Terry Terrell Ivy. Good morning, sir. Mr. Ivy, you're here today also charged with domestic violence battery.
Excuse me, Your Honor, he qualifies for pretrial.
I'm sorry?
He qualifies for pretrial.
Okay, the court will find that Mr. Ivy is insolvent and appoint the public defender's office to represent him. State has any objections to pretrial release in this case?
No, Your Honor.
All right, so we will release you, Mr. Ivy, on the pretrial release program. Mr. Ivey, please understand that if you paid attention to what has happened this morning, most people who are charged with domestic violence battery has to post a monetary bond. You've been released on pretrial release, which means that you don't have to pay a monetary bond. If you violate the conditions, you will be rearrested and you'll have to post a monetary bond. Court will order that you not have any contact with the victim, that you not return to the residence, and we'll give you, allow you a one-time opportunity to go with law enforcement to pick up any personal belongings. All right, thank you. All right, next is Aston Nooks. Okay, Mr. Nooks, you're also here charged with domestic violence battery. The court will enter plea of not guilty for you and appoint the public defender's office based upon your affidavit of insolvency. All right, Mr. Nooks, do you have a current address?
Yes, sir, I do.
And what is your address?
2801 South Park Street, Sanford, Florida.
And that's the a permanent address, sir?
Correct, sir. We'll set a bond of $5,000 for you and order that you have no contact with the victim except in legal proceedings. And so if you have to come to court with the victim in the case, you're permitted to come to court, but you're not permitted to have any hostile contact with her even while you're in court. Outside the court setting, you'll be ordered not to have any contact with the victim or go to the victim's residence. All right, the court is appointing the public defender's office in your case. Counsel, do you have questions, any comments?
No.
All right, thank you. All right, do you understand? Okay, is there something else to bring to the court's attention? All right, thank you. All right, next is Throcrom Rose. It's a domestic battery case currently set at no bond, and the court will.
He has a victim present, Your Honor.
Yeah, I see that.
All right, so based upon your affidavit, the court will find you insolvent and appoint the public defender's office to represent you. All right, so we have a witness in Mr. Rose's case. Let's swear the witness in.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do, thank you.
Please speak up.
Yes, I do.
Come.
Yes, I do.
Please state your name for the record.
Stephanie Lero,
And spell your last name for us, please.
Lero.
All right, Ms. Lero, you know the defendant, Mr. Rose, correct?
That is correct.
And you want to offer some comments to the court in his behalf?
I actually would, I'm trying for I'm very much interested in getting a restraining order. I was trying to do that this morning for an emergency injunction. We have a history of domestic violence.
Okay, well, there's a process for applying for domestic violence and injunctions, and there are help centers that you go to that will help you, and you could go to the clerk of the court's office, and I believe that they can help you with that.
Yes, sir.
Okay, did you, but at this point, you do not want Mr. Rose to come back?
No, sir.
All right. Is there anything else you want to tell us?
Just that we have a history of domestic, and I don't want any contact with him because it's getting worse and worse.
All right.
Um,
All right, does
Your Honor.
count, does the state have any questions to ask?
Not for the victim, Your Honor.
All right, does the defense have questions to ask? Ms.
Not-
Lero?
Not of the victim, Your Honor. I did have a challenge as to the probable cause affidavit.
Your Honor, state has no objection. I believe the wrong report got sent in. So state would ask for a 24-hour reset to perfect PC.
This would also be asking that you set a monetary bond in the alternative. If he bonds out, then he waives any defects in the probable cause affidavit. If not, then he's brought back here, where we can get the bond.
Yeah.
Okay. Does the state have any additional information besides what is listed in the arrest affidavit?
Not at this time, Your Honor.
All right, we will reset this for tomorrow, 24 hours for, to determine the issue of probable cause because it is not established by the current affidavit. We'll set the current bond at $2,500. Order that the defendant have no contact with the victim, and also order that he not return to the address where this incident occurred, which is 3033 Hammersmith Road in Orlando. All right, Mr. Rose, do you understand the special conditions?
Yes, sir.
All right, you heard the victim who indicated that she no longer desired to have any contact with you. Court has also ordered that you have no contact with her and that you not go back to the residence. Any questions about that?
My only condition would be if he could go back with law enforcement to gather any belongings he may have at the residence, but he has to.
Do you have belongings at the residence, Mr. Rose? Okay, so the court will permit him one opportunity to go back with law enforcement to collect his personal belongings. All right, so ma'am, you understand that?
Absolutely, yes, sir.
All right, so, thank you.
I'm giving you a card. It has the case number on it. You don't get the injunction through the state, but through the clerk. But if you have questions, you can call the state, and we can usually help you through it, okay?
Okay, thank you. Next is Nicholas Tyler, a blocker. All right, good morning, Mr. Blocker. Are you here on the charge of violation of probation? It's alleged that you violated your probation by committing a new law violation, that is, driving while your license had been suspended or revoked as a habitual traffic offender. The court will enter a not guilty plea for you, and your case will be scheduled for a violation hearing. Did you, by chance, complete an affidavit? Do we have an affidavit for?
Your Honor, it's an out-of-county warrant, so we wouldn't appoint a PD here. He would just be given his bond and be either bonded out or transferred to that county.
That is correct, Your Honor.
All right, thank you. All right, so it's actually a violation of probation from Seminole County, and so you'll be transferred back to Seminole County, and an attorney will be appointed to represent you once you return to Seminole County. All right, thank you.
Your Honor, to be clear, it's a zero bond on the warrant.
There's no bond, no bond. Next up is Joshua Zephyr. Okay, Mr. Zephyr, you were arrested on a warrant out of Seminole County. The charges are violation of probation, but the bond is $2,000. So, but you will be transported back to Seminole County to deal with this charge. All right, thank you. Next is Nicole Renee Christ. All right, good morning, ma'am. You're here today in the first case, it's 2021 CF 6042. And that case, you're charged with violation of probation, and no bond has been set for you on that charge. And it appears that probation violation is based upon a shoplifting offense. And you have a second case, which is 2021 60, actually it's 2021 CF 8584. That's also a violation of probation case. There's no bond authorized in that case. All right, and I'm assuming that the violation is based upon the same shoplifting charge I mentioned earlier at the family or at the Dollar Tree located at 987 North Cimarron Boulevard. So, and then there's another case, which is 2021 CF 8584. All right, okay, let's see. All right, we already mentioned that one. And
Correct. She has 5 cases.
And then there's case 2022 MM 6425. In that case, you're charged with giving false information to a law enforcement officer and retail theft. The bond on the false information charge is $500. It's $250 on the retail theft charge. Do we call all of our cases?
And Your Honor, see what else for,
Okay, and thank you. It's 2021 CF 6042. And that is also a violation of probation. And it appears that the violation is based upon the shoplifting allegations that I mentioned earlier at the Dollar Tree. The court will find you insolvent, and there's no bond on the violation case. The court will find you insolvent and appoint the public defender's office to represent you in all of your cases.
Your Honor, she has 2 additional cases. They're failure to appear warrants.
All right, I think I mentioned that one. The failure to appear is 8584, and I don't know what.
You mentioned the on-view violations.
All right, can the state help the court out with this?
I think, Your Honor, I think
And
it's,
listen, in 2021 CF 6042, the charge appears to be, it says failure to appear.
they're petty thefts and a battery, Your Honor.
Okay,
And the bond is set at 9. And then it looks like in 2021 CF 8584AO, she has 2 additional failures to appear, and that is for a burglary of a conveyance and an additional petty theft, Your Honor. And those are also set at 0.
okay, so the court will leave those at no bond, all right. We stayed at no bond. And we'll find Ms. Kristen Solvent, and the public defender's office will be appointed in all of her cases. All right, thank you.
Thank you, Your Honor.
Gerard Jordan Culver. Good morning, sir. All right, Mr. Culver, you were arrested on a warrant. The charge is violation of probation. It's alleged that you violated your probation by testing positive for marijuana. No bond on the violation of probation charge. And the court will appoint the public defender's office to represent you.
Thank you.
Thank you, thank you. Jared Brandon Diaz. Good morning, Mr. Diaz. You're also here on a violation of probation charge. No bond has been set in your case because it's a violation charge. It's alleged that you violated condition E of your probation by committing the new offense of domestic violence battery on September 3rd in Seminole County. So the charge is violation of probation, and the public defender's office will be appointed in your case. All right, thank you. You might want to ask your lawyer about it if, well, I always advise people to speak to their lawyer because if you make admissions about your case, you're stuck with them. Okay, all right, does counsel have a question for the court?
He stated he bonded out in Seminole County for this charge, Your Honor.
But this is, let me have it, it's a violation of probation case.
He's saying he bonded out of Seminole County for the violation of probation. I don't know how.
Yes, sir. They gave me a bond on my VOP in Seminole County, and I bonded out. And when I went to check in probation yesterday, I still got arrested for the same exact VOP. So it wouldn't make sense why I'm getting arrested twice for the same exact incident.
Well, that is sort of unusual because
Sure it is.
this is a different county from Seminole County.
Yes, sir.
And
All that's public records, though. If you look online, it's,
okay, well, I suggest this, that you provide that information to your lawyer and have your lawyer straighten out, but normally Seminole County wouldn't allow you to post a bond in an Orange County case. I don't know how that would work, but
yes, sir.
but give the information to your lawyer and she could help you out with that. All right, thank you. Okay, next up is Chesnell Dorcius.
And
All right.
defense will waive, Your Honor.
All right, so Mr. Dorcius is charged with violation of probation. There's no bond. The public defender's office will be appointed, and they're waiving appearance from Mr. Dorcius. Jonathan
Your
Gutierrez.
Honor, he also has an additional case of petty theft.
Sorry?
He also has another case. Mr. Dorcius.
Okay, Mr. Dorcius also have a second case of petty theft. The bond is $250 on a petty theft charge, and the public defender's office will also be appointed in that case as well. All right, thank you.
And Your Honor, state would ask for no contact and no return to 5536 Hoover Drive.
The court will order that he not return to the address where this offense occurred, and again, that's 5536 Hoover Drive in Orlando. No contact with the victim or the witnesses. Thank you. Next is Jonathan Torres. Is okay, thank you.
Defense will waive, Your Honor.
Okay, thank you. Mr. Torres is charged with violation of probation and no bond. The public defender's office is appointed and waiving appearance for Mr. Torres. All right, he has two cases, 2019 CF 13010 and it's 2019 CF 13009, which is also a violation of probation charge. And so the court will appoint the public defender's office in each of his two cases and set them for hearings. Thank you. Gerald Levert Jones. Okay, good morning, Mr. Jones. You're here today. You're charged with violation of community control. All right, it's alleged that you violated a number of conditions of your community control. It's alleged, first of all, that you violated condition 19 by being away from your approved residence on May 12th at 3:36 a.m. without the approval of your community control officer. It's alleged that you violate condition 5 by committing the new offense of driving while being under influence of an alcoholic beverage, also on May 12th in Seminole County. It's alleged that there's another violation of condition 5 by possessing a weapon or ammunition by a convicted felon on May 12th in Seminole County. You're also charged with violating your probation by allegations of improper exhibition of a firearm or dangerous weapon, May 12th, 2022, Seminole County. It's also alleged that on May 12th that you were in possession of cocaine. And it's alleged that you violated condition 4, that you violated condition 4 by being in possession of a firearm as a convicted felon. The court will enter not guilty plea for you and set your case for hearing. The public defender's office will be appointed in your case. All right, thank you, sir. Salvian Lambert. Okay, you and Mr. Lambert?
Yes, sir.
All right, thank you. Mr. Lambert, you're here also on the charge of violation of community control. No bond has been set for you. It's alleged that you violated your community control by being away from your approved residence on the 28th of August at 1:25, well, between 1:25 p.m. and 2:46 p.m. Court will enter plea of not guilty for you. Well, all right, and it's also alleged that you violated your community control by failing to complete your community service, not writing a letter of apology, failure to pay your fines, failing to pay the cost of supervision fee, and for not being at your residence on September 5th between 12:28 and 12:35 p.m. Again, charge of violation of community control, no bond, and the public defender's office is being appointed. Thank you. Next up is Janet Overstreet. Ms. Overstreet, you're here on the charge of violation of probation. It's alleged that you violate your probation. You might not want to talk to me about this. I'm appointing an attorney from the Public Defender's Office to represent you. You might ask them any questions that you might have. It's alleged in this case that you violated your probation by committing a new law violation, that is petty theft, on September 19th. Again, the court will find you insolvent, appoint the Public Defender's Office. Again, it's a violation of probation case, no bond. All right, counsel, do you have something else? All right, thank you. Next up is Albert Walmer. Okay, Mr. Walmer, you're here today on a charge of violation of probation. This is a pretty old case, but it's 2008 CF 57640. But it's alleged that you violated your probation by failing to make monthly reports and by failing to report to the probation officer's office as you were instructed. So the charge is violation of probation.
Your Honor, may I say one thing, please?
Well, it's not, it could very much.
I understand, it's relative, I'm just.
Oh, okay, well, what I'm,
Prison for the last 15 years, that's the reason I'm here.
okay, well, then I suggest that you have your lawyer file a motion to dismiss, indicating that you couldn't comply because you've been in prison. But at this point, the court appointed a lawyer to help you with that. Okay, I'll not dismiss the charges today.
I just wanted to know if I can get the expedited court hearing then.
We don't have any expedited court hearings. We have a system where everybody's case gets set according to the schedule of the judge who this case is assigned to. When we don't give preferences or we don't have expedited hearings for anyone, because everybody would be asking for one. But the charge is violation of probation, no bond, and the Public Defender's Office is being appointed. And again, they can help you with that. All right, thank you. Okay, next is Carl Edwin Anglade. All right, good morning, Mr. Anglade. You're here on the charge of violation of community control, no bond on violation of community control cases. It's alleged that you violate your community control by being away from your approved residence at 5547 Conroy Road, Apartment 3 on September 5th of this year. Charges violation of community control, no bond.
I believe we're waiting on a Creole interpreter, no?
I'm sorry? Okay, shit, you're gonna. Okay, I think we're gonna need an interpreter. This
Let me see if I see. Let's do it. Let me see if 104.
Okay, let's take up the 33-day motions while we're waiting on the Creole interpreter for Mr. Anglady. All right, the first case is that of Roderick Smith, that's 22 CF 9665.
Granted, notice non-filing.
All right, so the court is granting the motion. Also, a 33-day motion, and the case is Tyrone Trammell Johnson, 22 CF 9384.
Granted, notice non-filing.
All right, so the court is granting the motion for release. All right, next is Nicole Doreen Daniels, 22 CF 9590.
Granted, it was no build.
All right, the court is granting the motion. Next case is Jonathan Marrero
Ortiz, that's 22 CF 7563.
Denied, and information was filed.
All right, that motion will be denied. Next is Shaquille Najee Irby, 22 CF 9713.
Granted, notice of non-filing.
That motion will be granted. Next is Anderley Duryea Brown Jr., 22 CF 9084.
Denied, and information was filed.
The motion is denied by the court. Next is Amin Allen, 22 CF 9569.
Granted, notice of non-filing.
That motion is granted by the court. Next is Marcus J. Walker, case 22 CF 9072.
That was Mr. Baker.
I stand corrected. Marcus J. Baker, 22 CF 9072.
Denied, and information was filed.
That motion is denied by the court. Next is Shawanda Lee Schaefer, 229682.
Granted, notice of non-filing.
That motion is granted by the court. Next is Joshua Forcier, 22 CF 9616.
Denied, and information was filed.
All right, that motion is being denied by the court. We also have case 22 CF 9774, Dennis Pagan.
Granted, it was no billed.
All right, that motion is granted by the court. And the last one I have is case 22 CF 9721, Krishan Manuel Barnes.
Granted, notice of non-filing.
All right, that motion is being granted by the court.
He understands. He can do English.
Yeah. Okay, we could try it, and if it doesn't, if Mr. Anglade doesn't understand, we'll have to roll it over till this afternoon because no Creole interpreter is currently available.
Your Honor, he understands English.
Okay, all right, sir, would you go ahead and tell me your name, please?
Anglade.
Okay, Mr. Anglade, you're here today, and you've been arrested on a warrant, and the charge is violation of community control, and no bond has been set in your case. It's alleged that you violated your community control by being away from your approved residence on September 5th of this year. It's also alleged that you violated your community control by failing to make your restitutions payments. It's alleged that you violated your community control by failing to pay the court fines and fees. And it's also alleged that you violated your community control by not paying your costs of supervision fees. So the charge is violation of community control. Do you understand that?
Yes, sir.
All right, the court will appoint the public defender's office to represent you. And there's
a witness who has appeared today and wants to offer some testimonies to the court. Let's swear the witness in.
Raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record.
Candy Holly.
And would you spell your last name for us?
Holley.
Holley.
Yeah.
All right, and Ms. Holly, do you have something that you want the court to hear on behalf of Mr. Anglady?
Yes, on the 5th that he violated, he was actually in the hospital because I took him to the hospital. And I brought the paperwork to prove that.
Okay. Okay, well, I think that this is, again, something that has to be resolved at a hearing, and that paperwork needs to be provided to Mr. Anglady's defense attorney. But whatever information you have, you can provide it to the attorney at the public defender's office who will be representing him, and he can, that person can bring that information to the attention of the court and to the state, and perhaps it can be resolved. And so if you have evidence, that's how it should be handled. We do not take evidence during this proceeding. All right, thank you.
Thank you. Ms. Holly, he does have a in-jail arraignment for the VOP on the 29th. So just make sure you get that paperwork to his PD by the 29th, and that will be the hearing where they'll go into his paperwork. She's coming to get it for me now.
Okay, I'm done with the paperwork I have. Okay, can corrections tell me when or how long it'll take you need to get ready for the afternoon session? I'm just trying to figure out how much time you need to get ready for the afternoon session. Okay. All right, how about pre-trial release? Can you be ready to go at noon? Okay. How about the state?
That's fine, Your Honor.
All right, counsel. Can you be ready to go at noon? Is that enough time for you guys? All right, thank you. All right, we'll be in recess until noon. Thank you.